Welcome to Stolen, the world's greatest eminent domain podcast. Legally, the government has the power to take your property, but most people don't know what to do when it actually happens. If you don't respond correctly, you could walk away with far less than you're owed. And when that happens, in effect, the government steals your property. Our mission is simple: protect property owners, make sure they get the compensation they deserve. The government will steal your property, but only if you let them. Hey, welcome to Stolen, the world's greatest eminent domain podcast. I'm Chad Brown. I'm your host, here with my co-host, Kelo Wheeler.
Hey, everybody. Chad's good to be back. Thank you for having me.
Yeah, it's good to be here. We are excited today. We're diving deep into some case law today, something we don't usually do, but today we are diving into Kelo v. the City of New London. Yes, the Constitution does limit eminent domain. It limits it to cases of taking private property for public use with just compensation, which has tons of issues inside of it. But the issue we're going to look at today is public use, and we're going to look at it through the lens of Kelo v. City of New London, which is a primary case that looks at this issue of, can the government either through itself or through entities it creates, allow private citizens to take private property for public use? It's controversial, but it's not really unclear what the law says about it. And that's what we're diving into today. So with that, Caleb, we're headed to the great state of Connecticut.
Yes.
Connecticut.
It's a very cold place. Very cold. It's beautiful, though. Connecticut, if you've never been, it is gorgeous. I've been to Hartford, and it was very, very beautiful. But it's also, it can be like 40 degrees in June. It's ridiculous.
Yeah, okay, it's got nothing to do with what we're talking about.
Nothing.
Okay, so what we're talking about is the great state of Connecticut. And the real question we have to sort of resolve is the great state of Connecticut great for property owners and eminent domain cases in light of Kelo v. City of New London? Man, we got so much to cover today. Yes. Enough with the banter. Let's dive in.
Yes.
Kelo v. City of New London. What in the world is that all about?
Yeah, so Kelo essentially, and you kind of alluded to this earlier, but Kelo essentially explores the idea of public use into it kind of expands the idea of public use and what that actually is in the context of eminent domain. So let me give you a little backdrop here. And I want to throw some names out that people are probably very familiar with, especially since we've had COVID and been ransacked with that. But this is back in 2005. And in World War II, I'm going to go back all the way to World War II, but briefly. World War II Naval Underwater Warfare Center was at New London, Connecticut. Okay.
Naval Underwater Warfare Center.
Yeah, there was a naval, there was a warfare center there. And so an underwater warfare center, which was there until I think the 80s or the 90s. Anyways, they shut it down. Okay. Thus causing economic hardship for the city of New London. Okay. The Connecticut legislature then went on to pass a law which allowed for the cities to, by statute, condemn private property for economic development. Okay. And so New London creates this New London Economic Development Company and this private entity that would help them plan and develop areas around New London. Interestingly enough, this company called Pfizer, who we're all very familiar with, comes along and says, hey, we'd like to build a research facility in New London, Connecticut.
Okay, so stop saying. So Connecticut legislature says, hey, we're going to allow the creation of private companies that can take private property for economic development.
That's right.
And the city of New London on hard times.
Was in hard times, yes.
Government was there, supported the economy. Government through this naval adventure pulls out. They're having a hard time there in the city of New London, and they've decided, we're going to use this law to be able to improve our city.
That's right, to improve the city.
And Pfizer, being the good Samaritan that they are,
yes,
just always concerned big corporate America looking out for the little guy says, this is a great opportunity for us to invest in the great state of Connecticut and be able to help
Right.
revitalize the decimated city of New London. And here comes Pfizer wearing their white cape to the rescue.
That's right.
All right.
So
what happened?
So the city of New London, through its agent, starts working with Pfizer and other companies to create this plan to basically revitalize New London through condemning property or buying property from private landowners, and then converting that into a park, and then parts of it will be converted into commercial buildings, shops, centers, and some residential lots as well. And so what happened essentially is you have this private landowner named Suzette Kelo.
Okay.
And I'm not doxing her. It's all over the, legal textbooks, her name.
Right. Okay.
So I'm not doxing her at all. But Suzette Kelo, her and a lady named Wilhelmina Derry and her husband Charles, they are plaintiffs in the suit, hence Kelo versus New London.
Okay. Because this nice lady, Miss Kelo,
That's right,
is somehow being affected by this project.
Exactly.
So what are they suing? What actually happens to them specifically that leads them to initiate this lawsuit versus the city of New London?
So their properties, which by the way were not blighted at all.
Okay.
And we're going to talk about blight here in a second.
Yeah.
But their properties were not blighted. They were okay properties. These were good properties. They were living in them, and they were renting them out. These are property owners in the wake or in the way of this new development that's going to supposedly revitalize New London.
Right.
And so they go ahead and preemptively sue the city to get a court to say they could not take their properties because there was no public use. In their opinion, the property would be taken from them and then given to a development corporation.
Okay, so let's back up a second though. So Miss Kelo, she's her property, I'm sure, was just some landlocked property with no view, and it was really, she should have just been glad that they were going to come in and give her money for her property in this poorly developed, failing community, right? That's where her property was?
No, it was literally on the river, the Thames River. The Thames River in
Thames.
Yeah, rhymes with what?
James, yeah. Not Thames.
Not the Thames River, the Thames River.
Spelled the same.
Exact same way.
Very good.
Yeah.
And the dairies.
Yes.
Dery.
Not Dary.
No cows here.
No cows. We're not dealing with cows.
But they got land. But Miss Kelo got land on she got land on the Thames River.
I think they both did, but I know she did.
Okay.
Yeah.
So she says, "Oh,
wait a minute.
Oh.
That property had been her family for quite a while, and then the Derry's house, Miss Derry had been in that house since 1918, and we're talking about 2005.
Okay, so basically, at the risk of like this massive trope stereotype,
yeah.
We've got little old ladies who've been in their property for 3 generations, yeah. And Pfizer with its white cape has flown in and taken their properties on the beautiful Thames River.
Well, not Pfizer. They didn't take the property. The city took it, but it was for the benefit of people like Pfizer. And come to find out, Pfizer would eventually build on the property they took.
Okay, so Pfizer's not actually taking the property. No. It's this development company with the city of New London that's taking it. But don't kid yourself; it's for the benefit of Pfizer.
Yes, amongst other people.
Okay,
private entities as well.
All right, so they sued.
They sued them preemptively. The Supreme Court of Connecticut said that they could take the property. They, being the government, could take the property for the benefit of private parties.
So they weren't using judicial activism. They looked at the rule and said, "Hey, there's a rule. The rules here."
The Connecticut legislature had previously passed a law saying that these cities, these entities, could take private property for the public use, and the public use being economic redevelopment. So that's an interesting issue all in itself. But
you get this issue where basically what the court is doing is interpreting the law as it's written.
Referring to the legislature.
They basically, in a broadly, would have said if Miss Kelo has a gripe, she should take it to the legislature.
Yeah, essentially they deferred to the legislature, and that's what the Connecticut Supreme Court did. And then the Supreme Court of the United States took it up on a writ of cert and which is basically the court saying, hey, send everything from this case, this lower court, up to our court so we can review it. And so writ of cert, this case gets sent to the United States Supreme Court. Okay, things get interesting because in the Supreme Court, we have a very divided court here. This is what we call a plurality decision.
5-4.
5-4.
For the city of New London.
Yeah. Yes. 5-4 in favor of the city of New London. And there the Supreme Court essentially held this, that the taking of private property for the benefit of for public use can be found even if it essentially just benefits the private property, another private owner. Because, and the court basically cited that there was a carefully planned out development plan that had supposedly, and notice, Chad, I said the word was going to supposedly benefit at least, create 1,000 more jobs. It was going to create tax revenue. It was going to do all these things to make New London a better place. And so the court deferred to the city of New London's carefully laid plans, the fact that Connecticut had passed a statute that allowed for this to happen. And they kind of ignored the fact that the property was not blighted and that, in fact, the Derrys and Ms. Kelo owned multiple properties that were in great condition.
Okay, so you've talked about this concept of blight several times. So let's just stop for a second. Let's talk about the concept of blight. And what I want you to do is go through and say, okay, what is blight, and why does that matter in the history of eminent domain legal decisions in various capacities? I don't want to talk about state specifics, but generally talk about how the history of blight had been tied to eminent domain use up until Kelo.
Yeah, sure. And talking about blight is actually super important because the cases that dealt with blight are what led the Supreme Court to this conclusion in Kelo. So it's actually kind of important to talk about. So Berman v. Parker was a 1954 case out of Washington, D.C. And the Supreme Court there said that it was okay for a public entity to condemn blighted properties to give to other private individuals.
Okay, so what's a blighted property?
A blighted property is simply this. This is a 1,000-foot view, okay? It's a property that is essentially dangerous to live in. It's dangerous. It's harmful. It is dilapidated. Properties that are otherwise uninhabitable because of just deterioration on the property. So in
DC in the 50s, you have an area. You have areas where basically they've for all intents and purposes been abandoned for any sort of residential or commercial use in any meaningful way to contribute to the community, so to speak. But it's not just enough that the properties run down. It's not just enough that maybe the properties aren't valuable. You have situations of blight where the properties or the area has become so run down, for lack of a better phrase, that it now becomes dangerous. So it's not just neutral. It's actually negatively impacting the community.
Well, arguably too, it's when you have that situation. This is a very important distinction to make, and that is when you have a property that is dilapidated like that, it's now become stifling to the economy.
Okay.
The economy is stifled because of that.
So not only is it negative in and of itself, it's so negative that it's actually impacting other areas just because it exists in the state that it is.
Well, Washington, D.C. there's not a whole lot of area available in Washington, D.C.
Yeah. Okay.
So, yeah.
So basically the court comes in Berman in 1954 case and says, when there's blight, we will allow there to be the taking by private entities for redevelopment, so we can take an extremely negative community scenario where there's a lot of variations of it, but and hopefully turn that around for economic development and make it a positive place.
That's exactly right.
Right.
And the second case that led up to this Kelo jurisprudence was essentially Hawaii Housing Authority versus Midkiff.
Okay.
This is an extremely important case. Hawaii has a lot of interesting eminent domain cases for obvious reasons. There's not a whole lot of land available in the Hawaiian Islands. So in Midkiff, you have this backdrop of 72 landowners in Hawaii. 72. Right. And everything else was leased.
Okay.
And so the state legislature, again, in Hawaii said, we're going to take the property from these 72 landowners and we're going to allocate it to the people who are leasing it with just compensation being given to those 72 landowners. And the reason they did that was because essentially they wanted to break up this land ownership oligopoly that Hawaii had because it was stifling economic growth in Hawaii.
Okay, so let's hold on a minute. Okay, so I get Berman. I get Berman v. Parker, where we've got a blighted area. Okay, without diving deep into Midkiff, you had an area that was sort of controlled by an oligopoly of property owners. That's not what happened here. There wasn't blight, and there wasn't a oligopoly of the property ownership. So, what's the holding? What's the takeaway from Kelo?
The takeaway is this: public use can be found even if the government takes your property and gives it to private entities. If that giving it to that private entity would spur economic growth, and that's a very high level taking from that case, but that is essentially it. And the court cites the fact that there was a state legislative act that allowed for it to happen, and number two, the fact that there was a carefully laid economic plan set in place, which was purported to give benefits to the community as a whole.
Okay, so let's talk about Kelo just briefly. So you have a dissent where Justice Sandra Day O'Connor,
yes,
rest in peace, Rehnquist,
rest in peace,
Scalia,
rest in peace,
Clarence Thomas,
he's still kicking.
They're not lining up a lot.
Not usually.
They come to it for different reasons. Like Thomas says, the original intent of the Constitution didn't clearly envision this, but Sandra Day O'Connor has this wonderful quote that I think really summarizes it well. Where she says what?
She says there's essentially the government can now take a Motel 6 and turn it into a Ritz-Carlton.
Yeah. All right. So let's we're gonna run out of time. It's always happens.
Already?
Yeah, we're gonna run out of time. So what are the takeaways? So the broad takeaway from Kelo is that you can have private entities take private land for public use. You're going to have to show that there's going to be a positive economic benefit to the community, and that's going to be enough.
That's not a very high bar to reach.
Well, the problem, and part of the problem is that any developer who comes in is going to be able to argue. I mean, just look at what they do now. So let's just say Amazon wants to come in and put a center here. What they're going to do when they're arguing for tax credits or tax benefit is talk about economic benefit to the community. So really, this seems wide open. But it didn't stay wide open. We don't have time to go state by state. No. But what was the initial reaction by a lot of states?
45 plus states enacted legislation that restricted this Kelo style taking stuff. The issue is that, well, for us especially in North Carolina, that didn't actually get passed.
Yeah,
it got stopped in the state.
So we're a Kelo state.
Yeah, essentially we can be.
But most states have come in. For example, South Carolina has come in and basically said, without getting into the particulars of the law, they basically come in and said, we're okay with blight.
That's a police power as well.
Yeah, we're okay with blight. What we're not okay with is this broad standard set by Kelo, because really it's any developer could probably make that argument with a little bit of time and money.
I should be able to have motels.
Right. Okay. So, all right, let's close with a few comments, because I think that there's some interesting. We're going to take some interesting takes here on the end. So our current commander in chief, leader of MAGA Nation,
Donald J. Trump,
in 2015. His comments on Kelo were,
he says this, and I quote, I happen to agree with Kelo 100%. Eminent domain is a necessity.
Yeah, I think as a real estate developer, that's a good take. I don't know in the interest of the people, that's a good take. Yeah. So if you look back in history a little bit, George W. W comes in and says, hold up, we're not going to allow the federal government to do this. Yes. And so there's restrictions on the federal government's ability to create private entities to take private property. So clearly in that respect, that you see the federal government pulling back in its in its ability to use eminent domain.
Right.
And I'm going to end with this. I'm going to be real honest. I don't really like Maxine Waters for lots of reasons. One, I just think she says a lot of stuff that's stupid. And that's regardless. I'm neutral politically, but she just says a lot of things that are stupid. But in great Southern parlance, even a blind hog will find an acorn every now and then. What was her take? Because I think this is a good way to close. Because I think this is really, I think there's a lot of truth in what she said.
So Maxine Waters championed the Private Property Rights Protection Act in 2009, which was roughly 4 years after the Kelo decision. Maxine Waters comes along with other Democratic lawmakers, and they championed this act to withhold federal funds to entities engaging in Kelo style takings. Because what the federal government likes to do a lot of times is, I'm going to take your money away if you don't listen to us.
Sure.
And so that's kind of what that act was all about.
But what was her rationale? In one sentence, what was her rationale for it?
Oh, that was going to negatively impact, older folks, those who were less fortunate, the elderly, I should say, not older folks, but Southern parlance.
Poorer communities.
More Southern parlance.
Which unfortunately often are minority communities.
Oftentimes they are. And it's and honestly, there's in South Carolina, there was a whole thing with the minority communities on the coast and close to Charleston,
right,
where they had an issue with eminent domain like that. Very similar to this.
Yeah, and so the reality is that if you look at Kelo and how it was decided, there was tremendous opening of the opportunity for private entities under the guise of economic development, being able to actually, maybe abuse that, and so there has been a pullback. All right. Yeah. Kelo is interesting.
It's very well.
I'm going to have to say I'm not sure that Kelo in the great state of Connecticut are very great fans when it comes to eminent domain. But regardless, all right. That's all we have. That's all we have for today. It's always good to get a little history lesson from Caleb. He seems to always be excited when we're diving into the history of these cases. So with that being said, that's all we've got. Tune in next time to Stolen, when we will be hitting issues that affect property owners, helping them get the just compensation they deserve. Subscribe. Till next time, take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.